So, what's the role of the judiciary in the state lawmaking process? Members of the state and federal judiciaries play a role in the California lawmaking process as part of our government system of checks and balances. For example, when California statutes or regulations are legally challenged, then the state or federal court that makes a determination establishes a policy for the state. Of course, California statutes and regulations may be challenged on either federal or state constitutional grounds. And as a result, both state and federal courts may play a role in the state lawmaking process. In addition to legal challenges, both federal and state courts may be called upon to interpret California statutes or regulations. So the judicial branch of the state and federal governments is granted, or they are granted, this sort of authority by the California and federal constitutions. In addition, the powers and duties of the judicial branch are enumerated in federal and state statutes. As you might imagine, statutory interpretation is a primary role of the judicial branch of government in terms of the state lawmaking process. In fact, the courts are regularly called upon to interpret state statutes and regulations. Now, sometimes, perhaps to the dismay of our elected officials in the executive and legislative branches of government, this third branch of government does play a crucial role in the state lawmaking process because the courts are determining what the legislative intent was of a statute or whether a regulation comports with the State Administrative Procedure Act or whether a statute or a regulation is actually constitutional or not. So it's this critical role that the judicial branch plays in the state lawmaking process. Now, occasionally the California legislature will pass a law that does not comport with either the state or federal constitutions, despite claims by judges that they leave lawmaking to the elected branches of government. When judges modify statutes or they provide a determination of how a statute or a regulation is going to be interpreted or applied, then in fact judges do play a role or a part in the state policy making. So from my vantage point, all three branches of government actually play an important role in developing state policy. When a statute, a regulation, or some other governmental action is found to violate a provision of the Constitution, whether it's the federal or state one, the courts can not only invalidate the law or the regulation or an executive order by the governor, but they can also impose injunctive or other relief that's tantamount to a new public policy being adopted. When provisions of law, like statutes or regulations, are unclear in certain respects, the courts can engage in statutory interpretation to clarify the law and to do their best to determine what the legislature was intending when they adopted that particular statute. So sometimes the court's interpretation of statutes is new public policy being issued. Generally speaking, the California courts are not really vested with the power to legislate, as this would conflict with our state constitutional separation of powers found in Section 3 of Article 3. Those are the roles of the legislative branch, with some secondary role of the executive branch of state government. However, the courts can and do become involved in developing public policy. In the landmark case of Serrano versus Priest, a California Supreme Court in 1971, it had originated as a class action lawsuit brought by public interest groups and attorneys on behalf of a class of all California public school pupils. And the case involved a pressing issue of the day. Public education is a fundamental right, and discrimination against poor and minority students. The California Supreme Court in Serrano versus Priest struck down California's public school general fund financing structure as a violation of our state constitution's equal protection guarantee. Under that system, per pupil expenditures had varied greatly and depended on a school district's tax base. and it resulted in tax-based disparities and significant inequalities in educational expenditures on a per pupil basis from school district to school district around the state. The court's decision in Serrano essentially gave instructions to the California legislature on what they would have to do to fix the state funding statutes. And of course, subsequently, the legislature did so. As I've mentioned before, the other way for the courts to make state public policy is through their interpretation of statutes. Sometimes the courts have to fill in the gap or discern what is the intent of the legislature. So in that case, there might be a statute that's unclear or silent. So federal courts also play a limited role because they too can address whether or not, for example, an adopted statute violates the federal constitution. So for parties that are involved in the legislative process, they have to recognize that both state and federal courts have long been involved in the adoption of policy based upon the role of the judiciary.